Good afternoon, and welcome to the concluding roundtable in our spring sprint toward crypto clarity. Our focus today is on DeFi and the American spirit. Since our first roundtable earlier this spring, we've had the opportunity to hear scholars, practitioners, and business leaders discuss the promises and the challenges that the Commission and others should consider in charting a new regulatory path forward for this industry in the United States. In today's roundtable, we'll spend some time considering where the boundaries lie between financial activity that should be regulated because it is intermediated by centralized entities and financial activity that does not involve such intermediaries and thus may be outside the scope of the securities laws. We're fortunate to end our roundtable series as we began with Troy Paredes as our moderator. Thank you, Troy, for making a second appearance. And as with each of our previous roundtables, we have a fantastic group of panelists today to help us understand what it means for finance to be decentralized. Before I conclude, I would like to express my appreciation for the enthusiasm that all of you have shown for this series of roundtables and for your contributions through engagement with the task force and through conversations elsewhere with the ideas our panelists have articulated on this platform. I also want to express my appreciation to the amazing team of people from the task force and throughout this building who've put in countless hours to make these roundtables happen. Watching the effort that has gone into planning these events, and believe me, Commission processes for planning this sort of thing are as thorough as anything else done at the Commission, has more than once made me wonder whether sprint was quite the right term for this effort. I don't have time to thank everybody involved, but I do particularly want to thank my team, and especially Samira Yunus, Ileana Chiabano, Robert Tepley, and Landon Zinda. In closing, I would like to remind everyone that this event is being streamed live and is being covered by multiple media outlets. Accordingly, please be aware that all remarks by Commission officials, participants, and members of our audience will be on the record. In addition, please remember that the participants in today's roundtable speak on their own behalf and that their views do not necessarily reflect the views of the Commission, the Commissioners, or members of the Commission staff. We're now ready to begin with remarks from Chairman Atkins, followed by Commissioner Crenshaw, Commissioner Ueda, and Commissioner Peirce. Mr. Chairman.
Oh, great. Well, thank you very much, Richard, and good afternoon to all of you here in our auditorium and online as well. So it's a great pleasure to be with you all today. Let me begin by thanking Commissioner Peirce and the Crypto Task Force for their organizing of today's event, and Commissioner Crenshaw and Commissioner Ueda for their participation as well. Of course, I very much thank all of you here on the roundtable, for panelists, and our moderator, Troy Paredes, for Commissioner Paredes, for your voluntary contribution of time and talent to this mighty endeavor that we're undertaking. So today's roundtable is entitled DeFi and the American Spirit. This is, I think, an apt title because the American values of economic liberty, private property rights, and innovation are in the DNA of DeFi, or decentralized finance, and the movement of that. Blockchains, of course, are a very creative and potentially revolutionary innovation that have us rethinking evidence of ownership and transfer of intellectual and economic property rights. They are shared databases that enable the ownership of a type of digital property called crypto assets without reliance on an intermediary or central party. Instead, these peer-to-peer networks incorporate an economic mechanism to encourage participants to validate and maintain the database in accordance with the network's rules. These are free market systems where users pay demand-based fees to network participants to have their transactions included within a so-called block of data with finite storage capacity. The prior U.S. government administration discouraged Americans from participating in these market-based systems by asserting through lawsuits, speeches, regulation, and threatened regulatory action that participants and staking as a service providers may be engaged in securities transactions. I'm grateful to the Division of Corporation Finance staff for clarifying its view that voluntary participation in proof of work or proof of stake network as a miner or validator or staking as a service provider is not within the scope of the federal securities laws. As happy as I am over that step, this statement is not a duly promulgated rule with the force of law, so we cannot stop there. The Securities and Exchange Commission must adopt a regulation based on the authority that Congress has given us. Another core feature of blockchain technology is the ability of individuals to have self-custody of crypto assets in a personal digital wallet. The right to have self-custody of one's private property is a foundational American value that should not disappear when one logs onto the internet. I'm in favor of affording greater flexibility to market participants to self-custody crypto assets, especially where intermediation imposes unnecessary transaction costs or restricts the ability to engage in staking and other on-chain activities. Unfortunately, the prior administration undermined innovation in self-custodial digital wallets and other on-chain technologies by asserting through regulatory actions that the developers of such software may be conducting brokerage activity. Engineers should not be subject to the federal securities laws solely for publishing this type of software code. As one court put it, it would be irrational to hold the developer of a self-driving car liable, and here quoting from the court's decision, quote, for a third party's use of the car to commit a traffic violation or rob a bank. In those circumstances, one would not sue the car company for facilitating the wrongdoing. They would sue the individual who committed the wrong. And here just recently, the Supreme Court, in a case regarding firearms, underlined that particular sentiment. Many entrepreneurs are developing software applications that are designed to function without administration by any operator. The idea of self-executing software code that's accessible to everyone but controlled by no one and that enables private peer-to-peer transactions may sound like science fiction. But blockchain technology makes possible an entirely new class of software that can perform these functions without an intermediary. I do not believe that we should allow a century-old regulatory framework to stifle innovation with technologies that could upend and, most importantly, improve and advance our current traditional intermediated model. We should not automatically fear the future. These on-chain self-executing software systems have proven to be resilient in the face of crises. While centralized platforms wavered and failed under recent stresses, many on-chain systems continue to operate as designed, pursuant to open source code. Most current securities rules and regulations are premised on the regulation of issuers and intermediaries, such as broker-dealers, investment advisors, exchanges, and clearing agencies. The drafters of these rules and regulations likely did not contemplate that self-executing software code might displace such issuers and intermediaries. I've asked the Commission's staff to explore whether further guidance or rulemaking may be helpful for enabling registrants to transact with these software systems in compliance with applicable law. I'm also excited about the use of on-chain software systems by issuers and intermediaries to eliminate economic frictions, increase capital efficiency, enable new types of financial products, and enhance liquidity. Current securities regulations already contemplate the use of new technologies by issuers and intermediaries, but I've asked the staff to go further and to consider whether amendments to the Commission's rules and regulations would be better suited to provide needed accommodation for issuers and intermediaries to seek to administer on-chain financial systems. So while the Commission and its staff work to propose fit-for-purpose rules of the road for on-chain financial markets, I've directed the staff to consider a conditional exemptive relief framework, or let's call it an innovation exemption, that would expeditiously allow registrants and non-registrants to bring on-chain products and services to market. An innovation exemption could help fulfill President Trump's vision to make America the, quote, crypto capital of the planet, unquote, by encouraging developers, entrepreneurs, and other firms that are willing to comply with certain conditions to innovate with on-chain technologies in the United States. So with that, thank you all very much for your attention, and thanks again to the participants for what I anticipate to be a really good give and take on the panel. And Troy, keep them in line and get all the best ideas out. But thank you all very much, and have a good afternoon.
Good afternoon. As we begin the final event of this Crypto Task Force series, I think this is a good opportunity to reflect on what has come out of these roundtables and where the task force and the Commission are going from here. These roundtables have highlighted that crypto is far from a monolith. We have heard a markedly diverse set of viewpoints from many different segments of the industry. We have heard, for example, from many non-SEC registered entities with varying views on whether they or their products should be required to register and be subject to SEC jurisdiction. I expect that this will be a key theme of today's DeFi panel. Back in November of 2021, I wrote an article detailing my views on the opportunities and challenges of DeFi, which I believe require industry and regulatory collaboration to develop compliant solutions. The issues I raised in that article related to market structure, transparency, and retail investor protection, among others, and still remain questions today. So I look forward to hearing the panelists' views on how we should approach these challenges. Beyond issues related to registration and jurisdictional lines, other roundtables have focused on current SEC registrants who want to continue operating under SEC oversight, but with altered regulatory requirements tailored to new types of products and technologies. In addition to these varied and sometimes competing regulatory views, we've heard different opinions on the technologies underlying digital asset products and services. We've heard panelists highlight advantages or disadvantages of particular technologies and give differing predictions on their capabilities to function effectively as part of a large, complex securities market. In sum, these roundtables have given us a lot to grapple with, to say the least. While the series was billed as a spring sprint towards crypto clarity, I am unsure whether we've identified much can be simply or quickly clarified. When it comes to crypto, it does not appear to me that the SEC is facing problems with ready or easy solutions. What we are facing is heightened expectations of rolling out major changes quickly to pave the way for crypto expansion into the capital markets. With issues this complex and stakes this high, it's better to do it right than fast. We need to grapple with the tough questions through the legally sanctioned process of formal rulemaking, as Chairman Atkins mentioned, with the full opportunity for notice and comment and public interest findings. I look forward to engaging with my fellow commissioners, the staff, and the public on what I hope will be a thoughtful and mission-driven rulemaking process for this space. Thank you to all for the roundtables you put on, all the work, and thank you all for being here today. Appreciate it.
Well, good afternoon, and thank you to the panelists and all of the attendees today for the Commission's fifth roundtable organized by the Crypto Task Force entitled DeFi and the American Spirit. Reflecting on the American spirit brings to mind the expedition of Meriwether Lewis and William Clark about 220 years ago on May 14, 1804. Lewis and Clark set out to explore the new Louisiana Territory, purchased the prior year by President Thomas Jefferson. The size of the United States had doubled overnight, but there were no reliable maps or established routes through the new land. Despite this daunting challenge, Lewis and Clark entered the wilderness to carry out their mission. While not nearly as fraught with personal danger, the Commission is similarly navigating through challenging new terrain and plunging into the regulatory wilderness under the leadership of Commissioner Peirce and the Crypto Task Force. While the Commission's tools, we don't use wagons and rope and pickaxes, but instead are things such as roundtables, public consultation, and economic analysis may be different. I am confident that our expedition can succeed in updating our rulebook to open up new opportunities for American investors and businesses. The SEC's treatment of decentralized finance and other emerging technologies over the past 4 years was not conducive to regulatory transparency and discouraged entrepreneurs and those developing DeFi from engaging with the Commission. However, that approach has recently changed under the Crypto Task Force, which is charged with coordinating the Commission's efforts to find answers to many pressing questions. Thus far, they have changed the SEC's posture on crypto, embraced difficult regulatory questions, and promoted transparency by engaging with market participants, driving innovation and change. This SEC is committed to high-quality regulation. High-quality regulation takes time, and administrative processes matter. For those who are involved in the development of DeFi, please be patient and work with the Commission and its staff towards achieving the best possible outcome. Although I am uncertain as to what the perfect regulation may look like, the path towards it begins with seeking input from the public. This journey towards regulatory clarity will likely be frustrating and may move in fits and starts. However, by learning from DeFi innovators and advocates, the Commission has a better chance at regulating securities transactions involving DeFi and protecting American investors who utilize decentralized financial services and products. Today's participants will provide knowledge and insight about DeFi's development and the existing regulatory barriers preventing growth. Such contributions will help the Commission attempt to strike the proper balance between its role as a regulator and its mandate to foster competition, efficiency, and capital formation. In DeFi, there is a landscape of new opportunities. People can transact directly with each other without relying on banks or other centralized intermediaries. The Commission should not refrain from engaging in oversight of novel areas simply because it involves thinking outside the existing framework. The legacy regulatory regime under the federal securities laws presupposes the existence and necessity of numerous intermediaries. I look forward to hearing from today's panelists as to whether such presumptions remain necessary. For example, in what types of situations do DeFi systems and smart contracts potentially eliminate the need for a financial intermediary, and how? In what situations should DeFi systems be deemed to fall outside the scope of the securities laws? What key safeguards are necessary when the securities laws apply to these arrangements? Lewis and Clark's journey lasted over 2 years and carved out an important path to facilitate westward expansion. In doing so, they provided a valuable contribution to American progress. Today's roundtable reflects the SEC's commitment to continued progress and its willingness to consider the roles of emerging technologies. As the Commission continues to move through the regulatory wilderness, it should remain true to its mission of protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation in its efforts to respond to market innovation. So thank you very much, and I look forward to the conversation.
Okay, we're almost there. We didn't bring you guys here to listen to us, but But I do want to welcome everyone who's watching, and I want to thank Chairman Atkins, Commissioner Crenshaw, and Commissioner Ueda for your remarks. And of course, I'm excited to be here for our final roundtable, DeFi and the American Spirit. Thank you, Troy, for coming back and joining us. We thought you did a fantastic job the first time around, so it's great to have you back with us again. We have high expectations based on your last performance. And thank you to all the panelists for taking the time to join us today. Over the past 4 months, the task force has held roundtables on security, status, trading, tokenization, and custody. These roundtables have provided invaluable input for the Commission and the task force and the rest of the staff here. It's informed our views and has improved our efforts and will continue to do so. The task force has hit the ground running in this sprint, as you've heard, but I do think that it's more likely to lead to a marathon toward regulatory clarity. I hope that it doesn't take as long as Lewis and Clark did with their expedition. I don't want to be doing this for 2 years, but I hope that we can make some progress, and I know that all of you will help us in making that progress. So you may be asking, what business does the SEC have in talking about regulating DeFi? Absolutely none is a reasonable answer, so maybe we should just stop now and go home. But as you know, it's Washington, and so we can't do things that fast. We have to, it's not that simple. Even getting to know regulation requires some talking, and that's what we're going to do today. What is DeFi? Bitcoin is decentralized finance, but it may not be what first comes to mind when you think about that topic. If we trust Google, it says that DeFi is a blockchain-based financial system that aims to replace traditional financial institutions with peer-to-peer transactions and smart contracts. It brings to mind decentralized networks which enable people to trade tokens and derivatives, engage in lending, or participate in prediction markets. Although sometimes referred to as DeFi platforms, DeFi is not a place people go to access services that someone else provides and controls. It's software code that people use to engage in the activity of transacting without a centralized intermediary. So we're to channel one of today's panelists, I do not go to a decentralized exchange, I make a decentralized exchange. Thank you, Peter, for that. DeFi defies our traditional permissioned world of intermediaries. It enables a person to engage with her peers through a protocol that is open to everybody on the same transparent terms. No need to get consent from any centralized gatekeeper. At its core, DeFi, which blockchain technology enables, is about the freedom to transact with your peers without permission, interference, or intermediation. And that is why DeFi resonates so deeply with the American spirit. Also resonant with the American spirit is the ability of people to publish written material without permission. Code is protected speech. Because the First Amendment protects someone who writes a DeFi software protocol and publishes it, the SEC has no authority to demand pre-publication approval rights, even for code that could be used to exchange securities. The SEC must not infringe on First Amendment rights by regulating someone who merely publishes code on the basis that others use that code to carry out activity that the SEC has traditionally regulated. If somebody else subsequently violates the law using the software protocol, the user, not the developer of the software, should face the music. But sometimes the writer of a protocol used to exchange securities does more than merely publish it. She might also operate, administer, or maintain a platform through which the code can be accessed and that takes custody of client assets or makes execution decisions for clients. In this and other instances, the coder or her platform might be subject to regulation for that conduct. If that conduct relates to securities, the SEC might have a role to play. I think it might be helpful to think about this in context of an enforcement case that the Commission brought 7 years ago, and that was its case against Zachary Coburn. That was a settled case, so we don't have the advantage of a court having wrestled with these facts, and the order is actually pretty sparse in detail. But Coburn developed the code for Ether Delta in exchange for ERC20 tokens. And under the Exchange Act, the SEC charged Coburn with causing Ether Delta's violation of the requirement to register as a securities exchange per Section 5 of the Exchange Act. Although, again, the details are pretty sketched out pretty lightly in that settlement order. I think there are some facts that could help spur discussion on which types of activities the SEC should reach. Coburn was the only person with the ability to alter the Ether Delta smart contract, as he was the only person with access to the private key for the administrator account, which could be used to change the permissible fees for transacting using Ether Delta or the address to which of the account to which those fees were then directed. The order book sat on a centralized server that was maintained by Ether Delta rather than on the Ethereum blockchain itself. So maybe some food for conversation at the panel today. Centralized entities that use DeFi protocols that someone else wrote to serve clients don't get a regulatory pass, of course. They can use that tool as much as they can use other kinds of tools. And centralized entities can't avoid regulation simply by rolling out the decentralized label. There's such a thing as DINO, decentralized in name only. With centralized entities, of course, comes the potential for fraud, conflicts of interest, principal agent problems, information asymmetries, and other issues that are common in traditional finance. And so those are the issues actually that DeFi was designed to address. But if you are dealing with centralized entities, that might be where the SEC's efforts are best spent, protecting investors not from their own use of open source software code to engage in transactions with their peers. We also don't need to protect them from writers of code, but from providers of financial services. I hope that today's discussion will help us to ensure that SEC regulation is able to reach activities and entities properly within its ambit, regardless of what label they bear, without prohibiting the exercise of individuals' rights to publish code and interact with that code. So now I'll hand it off to Troy. I'm looking forward to the conversation. Thank you.
Thank you, Commissioner Peirce, and everybody in the task force for the chance to be back and moderate the last of the roundtable. Very much looking forward to the discussion. Before we jump into the substance, let me walk through a few of the game plan points. This is as much for the panelists as for all of you to know how this is going to proceed. So the first thing I will say is that I'll be calling on people, but so that the first three folks aren't caught off guard. They don't know who they are yet. I'll tell you who you are. It's going to be Rebecca, and then Eric, and then Michael Mosier. And then I'd ask that you keep your responses, particularly this first go around, to no more than 2 or 3 minutes, so we have time to get everybody's views on the table, and then we can really get into the discussion. When responding, your bios are on the task force webpage, and it's an incredibly impressive group of individuals. So no need to give your bio, but you could just say your name and say your affiliation and leave it at that, and folks can take a look at the webpage to get more of the particulars on your impressive backgrounds. I'd ask next that you keep it as much as you can, even if it's more than you're otherwise willing to, as much as you can, engage and interactive with one another. I would ask that you get my attention if you want to chime in. I'll keep a queue, try to keep it moving. If there are things I hear that folks are talking about similar points, I may jump around a little bit and call somebody to see if they want to weigh in. But if you just get my attention, I'll keep the queue, and we can make sure that folks have a chance to weigh in, because the more engaging it is, I think the more productive it will be for the commission. If I interrupt, I apologize in advance for being rude, but if I interrupt, it's simply to try to keep it moving so we can make sure that everybody has an opportunity. Hopefully I don't need to do that, but just fair notice on the chance that I do. One thing I think would be very, very helpful is if you're using a particular term of art, jargon, what have you, that can be useful because it can be an efficient way to move the discussion along. At the same time, not everybody has the same understanding, or people may use a word a different way or use the same word differently, what have you. So if there's a key term you're using, take the 10 seconds to find your terms. That way it can just help make sure that any points of clarification can be highlighted at the outset. We'll go for about an hour and a half until just shy of 3 p.m. Eastern time. We'll then have a break, and then after the break, there will be audience questions. I'll cover this in a minute that folks can submit. I'll fold those in to discussion, piggybacking on a number of the things that came out in this particular session, and have a good discussion after the break as well. To that point, questions are encouraged. There's a table, as I understand it, in the entrance before you came into the auditorium. I think you can find that. If you want to submit a question, just write down your question. You can find somebody who's wearing a name tag that says I'm part of the crypto task force here at the SEC. Give it to them. And if you're joining online today, you can submit questions through the Commission's website at crypto@sec.gov, and just note roundtable question in the subject line so folks who are monitoring that know what you're reaching out on. And when all is said and done today, there will probably be some disagreement. Hopefully there'll be some agreement, but I think it will be most productive if there's a good, lively, engaging conversation. Going back to what Commissioner Peirce said in her remarks, there's a heck of a lot to think through, and I don't think we could have a better group of panelists to help the Commission do so. So, with all of that out of the way, Rebecca. So if you could start us off, set the stage, if you will, maybe the biggest question of all given the the roundtable today, and that is, how would you describe DeFi, and what are its distinctive features as compared to TradFi? And along those lines, is it too amorphous to define? Should we be okay with a more principles-based approach? Should we have something which is very nitty-gritty, technically technological in nature? And how does that inform, just as a general matter, the mindset that you think one ought to bring when trying to figure out DeFi, what it is, what its opportunities are, perhaps what some of the risks are, and what those implications then are in terms of thinking about what the appropriate regulatory framework ought to be?
Thanks so much, Troy. Thanks to the Commission for having me today and for convening this roundtable. DeFi stands for Decentralized Finance. I'll start at a very high level, the 30,000-foot view, and then try to get a little more into the weeds as I go in my short period of time. But none of industry regulators or policymakers, I think, have been able to come to a consensus on how to define DeFi. I typically define DeFi as a blockchain-based open software system that allows users to engage in economic transactions in a self-directed and entirely self-custodial manner without the need for traditional intermediaries. There are other people who, and a lot of regulators have defined it as simply a blockchain-based system that allows financial services. That is very broad and probably would encompass many of what even banks are trying to build today in terms of DeFi. In terms of their work with crypto assets. And some people have gotten very, very technical, as you suggested, Troy, to get into the details of, how the technology itself works, how smart contracts, which are pieces of self-executing code work, and the like. I think we also need to think about what is decentralization as we think about DeFi. Decentralization is a philosophy that generally espouses movement away from power, authority, or control being centralized with one entity or one actor, and moving towards a disintermediation or a dislocation of both actors, jurisdictions, and other dispersion of the concept of power and control. In terms of thinking about regulating DeFi today, and I'm sure we're going to get much more into the details about this, but I don't think it's actually necessary to either define decentralization or DeFi in order to determine whether a particular actor needs to be regulated. I think, as we heard in many of the opening statements, just publishing code alone is not regulatable via something like the Securities and Exchange Commission. But when we are thinking about what types of activities people are engaged in, we can understand where there may be an intersection of the law and technology, or the law and certain types of technological functions. I think algorithmic trading is a great corollary to think about it, because in theory, the algorithm that is making asset management or investment decisions could function on its own, but you have the investment advisors register even when they're using these algorithms and codes, because they can impose their judgment, they can override the algorithm when there are other types of concerns around it, and they do still, even when using code, take on certain types of control or authority activities that may require and does require in many instances regulation. So when you think about a decentralized exchange that is operating autonomously, much like the Uniswap code does, that doesn't seem to require, as of today, regulation of the people who built the code. But the question then becomes, well, what if you have independent third parties building Uniswap pools with tokenized securities, and who is responsible and for what in that type of activity? I think the other complicated, this is my last point, the other complicated piece with DeFi is a lot of the activities don't look like anything we are used to in traditional finance. So questions of holding keys to a multi-signature wallet that can pause a DeFi protocol in the case of emergency does not look anything necessarily like pulling the circuit breakers on the New York Stock Exchange or something like that. So I think moving away from just the definition of what we think of as DeFi or decentralization and really thinking about activities will move us forward in thinking about how we could regulate the space, if at all.
And just a real quick, and there'll be more opportunity, Rebecca, for you to pick up this point. But in addition to that distinction, as you were describing, you can say code on the one hand versus activities on the other, where does risk fit in is also part of the consideration, not only thinking about what are the activities, but what are the risks, and are those the kinds of risks for which a regulator should be playing a role or not? Is that part of it as well?
Great question. I think that there are three central risks that, no pun intended, that come from DeFi. One is cyber risk. I think when you really think about how these DeFi systems are built out, cyber is the most important because it is code and it is functioning autonomously, in at least for certain types of DeFi protocols. I think then there's also something called system management risk. It is there an intermediary, or is there somebody who has some form of control? Is that properly disclosed? And are they properly, I think, as we think about for Web 2 types of software platforms, protecting against certain vulnerabilities and the like. And then I think that there is potentially illicit finance risk, but the source of that comes from usage and other actors engaging in the space. And there are, I'm sure we'll get to this later, but there are ways to mitigate against that. But it doesn't look, it goes back to what I was saying before, something like holding the keys to a multi-signature wallet doesn't look the same as, the other types of traditional activities. One thing I wanted to follow up on was your question of what are the hallmarks of DeFi. I'm sure other panelists will get into that, but I think just to do it quickly, non-custodial, I think, is or self-custodial is a non-negotiable when you're thinking about DeFi. I would also say open source, so that everything is transparent and openly available. I think one of the much different than how DeFi is portrayed. It is not some shadow system that's being built in the dark. I think DeFi is open, transparent, and really trying to be built in the light, and autonomous as well, so that it can function without intermediaries.
Great. So I'm going to go a little bit out of my initial order because Peter's getting my attention. So I'm going to go ahead and have Peter jump in here, and then I'll come back to Eric.
Thanks, Troy. I just wanted to make a brief interjection on the question of risk and how we use it to define regulated entities. There's a very catchy phrase, same risk, same regulation, that often has a lot of wisdom to teach us. I think that, and Commissioner Peirce teed this up with a lot of discussion about First Amendment rights in this context. That's a utilitarian calculus, that we see out in the world that there are these harms that represent certain things that could be addressed through public policy initiatives, and that we could ultimately, through a consequentialist view of the world, improve the social utility of these markets, reduce investor harms. that kind of consequentialist calculation is almost always the right calculation to make, except where certain long-held American values are at stake with making that calculation. So I'd just briefly hearken to Ronald Dworkin, a personal hero of mine, who identified certain rights as trumps. That phrase unfortunately means something different now that we have a President Trump. But there's this notion that, yes, we're always going to want to try and craft our regulation or our way that we address public dilemmas with an eye towards maximizing the good. But at a certain point, even if it's the socially beneficial outcome, there are certain areas we don't tread in this country. At a certain point, a right, like my right to publish code, trumps the risk that that code creates in the world. And so the risk created by perhaps a DeFi trading algorithm that allows people to engage in decentralized exchange, which is a verb, not a noun in this case, might be very similar to the risks that we see in centralized exchanges and might lead to similar bad outcomes for individuals in America. But even given that there might be some same risk, same regulation questions at play here, we would not put a prior restraint on an American's ability to publish that software. And there's more we can discuss later, I'm sure, about past case law with the SEC and the First Amendment in, say, Lowe versus SEC, but I'll certainly hold off until then.
Yeah, let's hold off on Lowe versus SEC. Maybe we'll get to the particulars there, or at least the spirit of it. But, Peter, since we're with you at this moment, let me just pick up on one point, then I'm going to come back to Eric, and that is, given what you were just saying, is the principle for you that ought to be, if I'm describing it correctly, a constraint on what otherwise might be a set of considerations, almost a hierarchy of considerations in terms of how one thinks about approaching it. And people may have different hierarchies as they place different weights on all those different considerations and different value structures, et cetera, et cetera. So stipulating as to all of that, from your personal perspective, is the First Amendment the one that features most prominently?
From my personal perspective and from Coin Center, the organization where I am, that is most prominent, but it doesn't mean it's easy. I'm not a code is speech maximalist and you're never going to be able to regulate math, right? These things can become a parody of themselves and somewhat silly. And that's why, and we will get to SEC versus Lowe later, or Lowe versus SEC later, hopefully, but there is a lot of jurisprudence that's rich and incredibly important on the division between speech, per se, and professional conduct that mostly involves speech, which can be subject to prior restraint and regulation. I am a lawyer. I had to get barred in order to practice law. Most of practicing law is doing this silly thing I'm doing right now, which is speaking. Why is that prior restraint on my mostly speaking profession allowed? Because when I'm a lawyer that's barred and representing a client, I'm engaged in conduct. I'm acting on their behalf with their interests in mind. And yes, I'm mostly speaking, but you can damn well sure prior restraint my speech when I'm actually representing a client. Figuring that out in the DeFi world is very complicated, is very hard. But there is a rich, rich history of jurisprudence from our Supreme Court, which is one of the things that makes me very proud to be an American, that will help us here.
So, Eric, taking, in some sense, what Rebecca was saying, what Peter was saying, and melding a whole host of things together, markets. So if you open up an economics textbook, right, there'll be lots of chapters on competitive markets and what makes for a competitive marketplace, et cetera, et cetera, et cetera, and all of that. Extraordinarily important, consequential, and it goes to some of the points the commissioners and the chairman were making as well in terms of what the opportunity is in terms of markets and transacting that DeFi affords. On the one hand, when you think about it in kind of less technical, textbooky sorts of ways, the words that often get used are free markets, and another word that often gets used are fair markets. And oftentimes the two come together in terms of free and fair. It is sometimes the case that in conversation, those words aren't crisply defined, that there's an assumption as to what they mean or don't mean, and there's a lot of values as well as economics that are baked into those concepts. From your perspective, as you think about markets, be they free, be they fair, and what DeFi affords from a how we think about markets perspective as compared to more centralized marketplaces, what are your thoughts?
Hi, everyone. Thanks for having me. I didn't think 12 years ago when I got my first SEC subpoena that I'd be invited to come speak in front of you all. And I want to say sincerely that I appreciate the change of tone and the change of stance in the Commission. I think that's it's absolutely a positive for America. When it comes to markets, I think we have seen in crypto, in DeFi, the most American spirit rushing back in to help bring economic commerce back to where it should be. When we say words like the American spirit, I think we must recognize that that always entails a strong degree of rebellion, a strong degree of individual liberty, a strong degree of risk-taking, and a strong degree of entrepreneurialism. And starting from when Bitcoin emerged until now, with DeFi and everything that has grown up around it, it's hard not to see that as a reaction to what is supposed to be the freest country on earth, slowly decaying into one that encumbers all market participants in myriad ways. And when we see the rise of crypto, I think we must first understand it as a reaction, as a market-based reaction, because markets always find a way. And in crypto, in DeFi, we see this really coming back into force. And what would be helpful, I think, for anyone looking at this subject is to simply see the virtue and the courage in that kind of exploration. I think maybe culturally in America we have gotten a little complacent, a little comfortable. And crypto really reminds us that there is always a frontier and that we should be pursuing it. So to see it as a noble pursuit, something that is not swept under the rug and is not like some dark machine that we can't control, but is actually the reemergence of light back into financial systems, I think is an important starting point.
Is there a particular something from a regulatory perspective that you think would help, or at least not, that should be done to help advance what you just articulated, and or that shouldn't be done so as not to impede the advancement of what you just articulated?
Yeah, what is it in medicine, the Hippocratic Oath, right? First, do no harm. Is that right? Markets do not need a regulator to enable them. They are emergent phenomena. They occur without any kind of central power making it so. And just the first recognition from regulators that that's the case would be good. And then when you look at crypto and DeFi, you have to realize that these are actually machines of perfect regulation. That the way that a smart contract operates is a perfect regulator. It does precisely what it is told to do. It executes regardless of who is using it. It doesn't matter what your background is. It doesn't matter where you're from or what your skin color is. It doesn't matter your gender or your sexual orientation. It is a true blind rule of law machine. And it would be nice if the regulators who portray themselves as caring about the rule of law would understand that these mechanisms are themselves incredible new machines of regulation, and to simply stand in awe of them at first before trying to get into all their gears and break everything that makes them so beautiful.
Michael Mosier.
I'm going to do my best.
Well, I'll pose a question, but feel free to respond to what Eric was just saying. But as a piece of that, if you think about the ways in which the financial markets in the U.S. have developed over a very long period of time, and the regulatory infrastructure, and in part, the regulatory infrastructure has informed the ways in which the markets have developed, and the way the markets have developed has informed what policymakers think the regular right. So there's a bit of cause and effect and the arrow going both directions, and at this point we have what we have. But one of the defining characteristics of what we have is a regulatory framework across financial services, and the SEC is no exception, which is very intermediary-centric. Now, I think picking up on Eric's point, intermediaries may come into existence because they can reduce what can otherwise be transaction costs broadly defined in the marketplace. So they may just come about as a business opportunity to help parties transact or whatever it happens to be, to shoulder risk or what have you. There are other instances where the government says, you, by doing this, are this, that, or the other, and we regulate this, that, and the others, broker-dealer, et cetera, et cetera. So how do you think about it where we have a regulatory environment which is very intermediary-centric, just is the case descriptively, with DeFi decentralization, which at its core, its essence is not that? How do those things should policymakers be trying to reconcile? Should policymakers, in some sense, going back to what Rebecca was saying, a flavor of what Eric was saying, and then overall big picture considerations as Peter was saying, or just say, hey, you know what, we just need a whole new construct that we got to set aside approaches that are very intermediary-centric and just fundamentally think about it differently? Is that what they should do, or should they try to, square peg round hole? How should they approach it?
Yeah, thank you, Troy. I think Rebecca articulated a lot of the risks that we've thought through in the decentralized finance space, and I think it's not necessarily a wholesale difference. There's a lot to build on, but it is different. We're not. This isn't people shopping at a mall anymore. I mean, we've dealt with this with the advent of online commerce. It's different types of risk. So there was a time where it was people shopping in the mall. You needed a mall cop as fast as the fastest shoplifter, and you came up with cameras to watch for that sort of thing. That's not what's happening now. It's high frequency data packets that are moving at exceptional speeds. And in the same way that we move from telegraphs to switchboard operators to mobile phones, we changed the way that we dealt with risk. And the risk in the situation of a mobile phone is again, it's a communications risk. It's SIM swapping. It's not moving people back to switchboard operators because people are getting SIM swapped. And I think that's the opportunity here is to look at ways that we can automate the risk detection and make people safer rather than just injecting intermediaries. And some of this we've grappled with through many years. FinCEN used to regulate telegraphs as a financial institution. Actually, it's its own category. And then as there was more experience with what telegraphs were doing, it was realized, yes, they're transmitting communications data, but actually they are not a financial institution. They are a data transmitter, and they were exempted, actually, and they remain exempted from that. And there's a separate money services category specifically because data communications is not the same as financial activity, even though that some of that data might carry financial data. And part of that is recognizing that what are the risks? The risks here are cyber risks in many cases. And so we dealt with this in 2019 with the FinCEN guidance. We specifically said there are those who are accepting and transmitting value in a sense of having total independent control over it. And then there are those who are engaged in what we call a trade, which are software developers who are developing the data, communications, and network services that just allow things to move. And this is also not new. Like SWIFT moves data messages that account for actually around $5 trillion per day in dollar transaction between banks. This is communications data that's going between banks that the banks are then updating their internal ledgers. We have RPC nodes that have gone back to the 1970s that also allow networks to communicate across each other's networks and update internal ledgers in some form. Now we have public blockchains, which are public ledgers that are getting updated in real time. Those have many sorts of communications across them, whether it's at the block building stage to the batches, all the way to cross-chain communications. All of that is getting moved across different networks to allow other ledgers to update. Now they're public ledgers. So there's a lot of cyber risk in that I think there's opportunity to be managing, but it's opportunity to manage it in a way that can keep people far safer than collecting personal information of people, and just moving it back to switchboard operators that could then be exploited. And one last quick point on that, just actually almost crashed Perplexity AI the other day, looking up how many people have been victimized from banks losing their personal information over the last 5 years. It spun for about 20 minutes and then came up with about hundreds of millions, and that's all it could do. And I think this is one of the reasons why at FinCEN, when we were developing the 2019 guidance, we also did an initiative on privacy-enhancing technology with the concept that we have to factor not just the victims of ISIS in it, but the victims of the hundreds of millions of people who are also victimized when this information isn't taken care of. And the reason to bring in privacy-enhancing technology was that there are so many ways that we can do an exclusion proof that determines that someone's not on an OFAC list without sending their personal information around. And I think that's that type of zero-knowledge proof that can determine what is the activity that's happening here, what is it a bot loading up. Most of these bots that are causing some of these intrusions do not have a social security number, and actually we don't even care who they are. We're not going to extradite Lazarus Group. We see the activity and we can stop it, and that goes back to the activity-based sort of risk management that Rebecca was talking about. Peter.
Real quick.
This is a statistic we've quoted a number of times. The DOJ in 2012 found that identity theft accounts for double the amount of economic losses to individuals than all other forms of theft combined. So Perplexity AI struggles with quantifying it, and it is huge. And I would love to talk about identity more later.
And just real quick for Michael before I move on, and Jill, I'm going to come to you next with a question. But in terms of, Michael, what you were saying, do you see that risk as all of government, across financial services and beyond? Do you have a particular view as to what the SEC's role would be in that?
Yeah, I think the SEC has a tremendous opportunity to actually, when they're thinking through this cost-benefit analysis, to be factoring in both the risk of whether it's market manipulation or that someone is, well, actually a great example is someone an accredited investor. We don't need to send around everybody's information to determine that. That's a pretty basic proof. In fact, joined Espresso Systems back in the day with Jill, and one of the things that they were developing that inspired me to join them was zero-knowledge proof wrappers that could verify threshold proofs of whether somebody was, say, an accredited investor, whether they were over 21 at transaction speed. And I'll just one aside on that. As a former state prosecutor and someone who worked with victims of domestic violence, I remember talking to victims of domestic violence who would go in to buy a beer at a store and go up to the checkout, and they have to show their identity. You have to show everything about yourself in order to buy a beer. And so whoever that is who happens to be at that door, at that checkout, is seeing where you live, everything about you, when all we need to know is you're over 21. And I think that's the sort of piece that we were looking at FinCEN in particular to say there's a lot of risks here. There's ways to do this that protects people, and I think SEC is in a position, particularly with the volume that wants to come on to these public ledgers, to say when we do that cost-benefit analysis, it's going to be, here's other ways to manage this risk that takes in everybody's pain points, but also what is the tech that can be used to solve all of this, particularly factoring in, and I'll wrap up with this, but I think factoring in that we are in a stage of hyper-fast data transport now, and so we're not in a situation where a bank SAR officer can wait for the telex to come in, get printed out, look at it, send something up, determine if that person's a member of Lazarus. It's bots moving at a speed that are faster than people can detect, and that's a chance for us to leverage all the different activity-based risk detection that's much faster than a person. In fact, Chair Atkins mentioned car manufacturers. There was a study of over 200 billion miles worth of autonomous vehicles with autonomous risk detection. Over the 200 billion miles, when a car had the autonomous risk detection, the property damage went down 88%, and the bodily damage went down 92%. And I think that's the place that we're in right now, is that SEC has a position to, as we bring 200 billion miles worth of trading on chain, to use this activity-based detection that's going to reduce bodily injury, but not create more victims by sending PII around. I think that's an incredible opportunity.
Jill, so it's been a common theme for the afternoon so far, is the ways in which, not that there aren't complexities and lots of things to think through from a variety of different angles and vantage points, but the opportunity that decentralization, DeFi affords, not to say there aren't risks, but the opportunities as well, where you can kind of bottom line it as, again, was mentioned earlier in various of the commissioners and the chairman's remarks, in terms of peer-to-peer transacting. And if you kind of broaden the lens on peer-to-peer transacting, one of the lessons from economic history outside the context of blockchain and DeFi and decentralization is we can get people who don't know each other to transact. That can create opportunity for economic growth, prosperity, inclusiveness, and a lot of good can come from that. And the question is what the institutional frameworks that allow that to happen. Here, there's a technological framework that seems to have as its promise that potential. And yet at the same time, when it comes to markets, if you got a market over there and a market over there and a market over there and a market over there, there's something that can be said for that fragmentation that you might in terms of competition. At the same time, it may be, hey, if you can get those together, there may be additional opportunities in terms of liquidity and breadth of the market, depth of the market, what have you, and how does all that happen? Does it happen organically, going back to some of Eric's comments, or does it happen as a function of regulatory requirements that tries to stitch different marketplaces together, which all leads to, from a technological perspective, questions around interoperability and how technologically can different chains and activities, et cetera, be stitched together. So with that wind up, and feel free to challenge any of the wind up, but with that in mind, what are your thoughts?
Yeah, thank you. My name is Jill Gunter. I'm co-founder of a company called Espresso Systems, and we are working on exactly that, how multiple different chains or venues for settlement can work together more seamlessly in the blockchain native environment. As I reflect on the question, and in particular thinking about the benefits that can be brought to whether it's consumer investors, more institutional investors, with the technology that many of us on this stage have been developing over the last decade, I'm struck by all the potential that still remains, but also all that's been delivered already. I first got into this space when I was working on Wall Street. I joined Goldman Sachs on their credit trading desk shortly after 2008. Talk about a regulatory environment. As the junior person on the desk, I was tasked with understanding a lot of the Dodd-Frank regulations that were coming down the pipeline and working closely with compliance. And it was in that context that I first heard about Bitcoin and also the concept of smart contracts. And it struck me at the time how so much of what I was dealing with in my day-to-day, whether it was the rote processes of clearing and settlement that were still extremely manual, that again slid down the hill to the junior kids on the trading desk to deal with, or whether it was the processes of figuring out just how much leverage was in the system. All of this felt like it had the potential to be obviated by bringing things on-chain in a way that could be transparently audited in real time, while also enabling the protections of privacy that Michael touched upon earlier. Fast forward to approximately 10 years later, and FTX, a centralized exchange in crypto, collapsed. And I will never forget sitting behind my desk, watching the various DeFi monitors that I had up, and watching liquidations happen in an extraordinarily orderly process amongst all of the DeFi protocols. DeFi stood up. And while the FTX collapse, as someone who'd built their career in this industry, felt like a catastrophic failure, watching DeFi hold up under the pressure that it was under was an extraordinary experience as someone who'd gotten into this space for that promise, again, a decade prior. And so as I think about the benefits, one of my great hopes for the SEC and the other regulatory bodies in DC is that we not just focus on the risks, and there are indeed very real risks to consumers that come with the new technology, but also the potential that it brings to transform these markets. One thing that I want to highlight based on the question that you asked, Troy, is that blockchains are no longer monoliths. 10 years ago, they were. It was Bitcoin, it was Ethereum, maybe a handful of other systems, and those systems acted in a monolithic way. If you built something on Ethereum, there was the application, and there was the underlying Ethereum blockchain. Now they function in a very modular way. And so you're not just building on Ethereum, you're building on perhaps an interoperability layer, like what I'm working on. You're building on different data availability systems. You might be using different privacy protocols. And I think that it's very important in any of the guidance or rulemaking that moves forward over the coming months to bear that in mind. That in many cases, it's not the case that you can pinpoint a locus of whether control exists or does not, either at the application layer or within the blockchain. A much more complex approach is needed to understand where points of control might exist by founders or creators of these protocols, and where points of control no longer exist. And there might be many different components of the system under scrutiny that lie on different points of that spectrum. So that's a conversation that I hope that we get into.
Joe, just one quick follow-up. As a practical matter, how important is interoperability?
Oh, I think it's critical because it will exist no matter what. Markets, I believe I stand with Eric and I say that markets are emergent and they will evolve on their own, whether any of us in this room like it or not. And in our increasingly digital and global world, markets will find ways to collide. And so whether we allow them to collide and work together and interoperate safely, securely, with appropriate disclosures to consumers who might be using them in those ways, or whether we have to force them to collide in more chaotic ways or force those interactions between them underground or into spaces that don't have disclosures, it's going to happen. And so I think it's absolutely critical that we as technologists build the systems to allow that interoperability to happen safely, securely, while still meeting the standards that consumers expect, and that you all as regulators and overseers of the system create frameworks that are conducive to that.
Omid, I can see you, okay. I was looking down at the other end. So if I got this right, and I think I do, you wrote a book, a very interesting title, Re-Architecting Trust. And after the colon, the curse of history and the crypto cure for money markets and platforms from a couple of years ago. So 3 related questions here, piggybacking on that. What do you mean by re-architecting? What do you mean by trust? And what is the ill that crypto cures?
So first, thank you for having me, and it's so great that these events have been taking place. For anybody who's written a book, know that you usually have the title that you want to use, and then your editor and publisher tells you that you can't use it because it's not going to lead to enough clicks on Amazon. But I did stick to my grounds on something related to architecture because I think crypto is actually a very rare opportunity to change the architecture of finance in a fundamental way, and for the better, obviously. But a lot of what other people consider financial innovation has been very iterative over the years, and the core infrastructure might be mostly digital now, but the architecture of it is actually the same as the analog era, right? And we still call it a wire transfer, which goes back to the invention of the telegraph. So my interest in crypto is actually how it can achieve the goals that finance has been moving towards for centuries, but to do it in a fundamentally different way because of these new tools like cryptography and consensus mechanisms and even developments in mechanism design. So that was the impetus for the title. The problem it solves is that I think traditional finance some years ago sort of hit the limit of what it could achieve. And I think it's important not to dismiss that. There is a tendency within the crypto industry to treat quote-unquote TradFi as just being bad. But we would not have the modern successful economy that we do in America if it wasn't for the very robust financial markets that we have and the banking system that we have. And that wouldn't be possible without both the institutions and the regulators that got us here. But the problems of that system are becoming increasingly apparent, especially in the global digital economy. Mainly, almost none of it runs continuously. It is designed to sometimes present the the veneer of continuous operation, but the actual settlement is often done with significant delays. Two, the system is not transparent at all. This is one reason why TradFi needs to be heavily regulated, because otherwise it's practically impossible to know what's going on inside of it. And then three, it is extremely fragmented. There are many databases in TradFi, and they almost never directly talk to each other, partly because a lot of the systems are national and not designed for an international economy. So to me, the re-architecture opportunity is sort of start from the first principles of, well, what do we all agree is good? We all agree that continuous operation is good. We agree that transparency is good. We agree that interoperability is good. And then with crypto in general and DeFi in particular, how do we use these new tools to achieve all of the goals that we've been working towards for a very long time?
Where does trust fit in? Just to zero in on that word. And how do you think about trust in the context of all the things you just mentioned from a more technological perspective?
So trust to me is the only product of the financial services industry. Like at the end of the day, when we talk about banking, we talk about capital markets, securities, raising money, trading things, but if you zoom out, and this is something that I'm forced to do because I have to teach a class on this, what is it that all of these institutions provide? What's the product or service? It is trust. That for lenders and borrowers and buyers and sellers and entrepreneurs and operators, there are certain guaranteed outcomes that you get from the fairly esoteric world of money and finance. And we've had one model of how we've achieved it historically, which is that we have these institutions that show up and say, we're going to do it. Then regulators come and say, well, we need you to do it well, because when you fail, it's worse than almost any other industry failing. And usually there are rules. They are handed to the intermediaries, and they're asked to please follow them. And then if they don't, there are certain penalties that are entailed. With crypto, part of the re-architecture thesis, and this is the point that some of the other panelists have made, we could use code and cryptography to lead to certain guaranteed outcomes. And that's something that's never really been possible before.
Kevin, so glad you were jumping in because I was coming to you next, but let me just tee up a bit. This may be where you're going in any event. So you too have a book, more than one, but the one I'm going to call out is The Blockchain and the New Architecture of Trust. So similar questions in terms of architecture, in terms of trust, but you also have kind of a broader purview in terms of being professor of legal studies, ethics at Wharton. And so as you think about these themes that Omid was talking about and that have featured in other commenters' comments, what's your take on trust, on architecting, and in particular, what it means in terms of how we think about the regulatory environment in terms of what's warranted to regulate, and then the how you regulate it in light of what really are fundamental differences in terms of the technology and what it allows and what it may mean and how things get done, and the less dependence on intermediaries, again, picking up on what Omid and others have said.
Sure, thank you very much. It's a pleasure to be here. I was last in this room in 2019. I said 2018 to Commissioner Peirce, but the SEC had a fintech forum. I guess they couldn't call it the digital asset or blockchain or crypto forum back then, but we were not yet talking about DeFi. We were talking about many of these same issues, and that's one thing I want to start with. They're challenging issues. I think it's important to discuss the importance of innovation and the value of not being too worried about risks, but the reality is when we get into these issues, there are risks, and there are better and worse ways to address these issues, and we need to think about them, which I know we're starting to do in this discussion. Yeah, I wanted to jump in when Onan was talking about trust. I think I have a very simple definition of trust, and it's important to understand trust is not certainty. In fact, trust is something that happens in the absence of certainty. If I am absolutely 100% certain of what's going to happen, I don't need to have any trust. And this gets to, I think I take issue somewhat with what Eric was suggesting about smart contracts being perfect regulators. They are perfect to the extent that software is perfect. And we know that software is imperfect. There may be errors, there may be hacks. It may be that what we think we are telling the software to do is not what we are actually telling the software to do. It may be that when the software gets out in the world, it will interact in ways that we didn't anticipate and therefore will not produce a result that we anticipated. Same set of issues we're dealing with in the AI context with issues of alignment and so forth. So trust is about situations where we need confidence despite vulnerability. That's really all it is. It's the environment where actors are confident in moving forward and taking a risk, taking a leap of faith, despite the lack of absolute certainty. And to some extent, I think that's what regulators are trying to do. They're trying to facilitate markets. And it's true, markets will go where they want to go, but where they want to go may not be what's ultimately in everyone's best interest. United States capital markets are the best and deepest and in many ways most innovative in the world, not because they're the least regulated, but because we have the history of a very effective regulatory structure. And I think that's where we need to start with DeFi. And so on the question of trust, what I talk about in the book is that trust has architecture, just has structures. And I won't go into all the details, but all the traditional trust structures, even though they're still valuable and useful today, have reliance on some central actor. It might be a counterparty, it might be the government as a backstop, it might be some intermediary. And those are still valuable mechanisms of trust. They produce efficiencies and other kinds of social benefits, but there are limitations. And blockchain is a new kind of trust that does not get rid of the need for trust. Causes trust to be diffused in different kinds of actors and different kinds of activities, but eliminates the idea of a central locus of trust, one central point of failure or administrative control over the system. But then when we get to this regulatory question, we need to ask what's actually happening and what are our concerns. And I think one can start with looking at the text of the securities laws, but the reality is capital markets today look nothing like they did in the 1930s. They look nothing like they did probably in the 1970s or 1980s. We've had tremendous, unbelievable technological innovation and change. And so, for example, Rebecca is right that what it means to have a multi-sig contract for emergency suspension of a DeFi protocol is different than what a circuit breaker is in equities or other capital markets today. But those are both mechanisms of dealing with a real problem, which is in these complex adaptive markets, we have things like emergent harms. We have things like flash crashes happening, which is something that maybe didn't happen in the 1930s. Lots of other things happened in the 1930s. And so we need to think about what are the mechanisms consistent with both our ideals and our legal structure to address them. And so I think we need to come back and start with the concerns. And Rebecca earlier on mentioned several concerns about DeFi. My group, the Wharton Blockchain and Digital Asset Project, did a report on DeFi in 2021, actually 2 papers with the World Economic Forum. One's called DeFi Beyond the Hype. One's called DeFi Policymaker Toolkit. And in the toolkit, we go through 6 broad categories of risks and start to unpack how we might think about it. They don't all call for regulation. I'll just list them and then stop. But we should think about what do we need to do and what can we do most effectively in ways that have the minimum cost to innovation and to our values, things like freedom of speech, as Peter described, how to address them in the best possible way. We talked about financial risks. There are risks to investors in participating in these markets, various kinds of financial risks. There are technical risks, which I think is largely what's being described here under the rubric of cyber risk. But remember, these are all software systems in DeFi and blockchain. So everything at some level is a cyber risk, but there certainly are vulnerabilities and attacks and issues in the coding of the software. There are operational risks, things like key management, things like governance. There are legal risks in terms of these systems being used for illicit purposes. And there are emergent risks, things like flash crashes and flash loans and so forth, that are novel kinds of results of interacting systems. And so I think what should regulators do? They should go through and catalog the risks and then identify the appropriate ways consistent with the law to address those risks that are the most advantageous. And then to the extent that the law does not allow for that, think about how the law needs to change.
Great. So I'm going to go to Michael Jordan and then Gabe. Everybody chuckles when I say Michael Jordan here. But anyway, I'm going to go to Michael in a minute and then Gabe. But Eric, I don't know if there's anything you wanted to say. If not, that's okay. But if there's anything you wanted to say in light of some of the comments from Kevin.
Yeah. you're right. I shouldn't have said perfect. That's fair. I think what's important here is not that that the smart contracts are perfect regulators, but that they are a step function improvement over over human regulators, frankly. A famous or a wise person once said that America was special because it is a nation of laws and not of men. This is an appeal to the rule of law, basically the idea that a society that can move to a non-arbitrary form of rule is better than one that is based on the arbitrary whims of any human. Some people are good, some people are bad, many people are bad and they think they're good. But no matter what, we're all subjective humans and we make mistakes and we're squishy in our points of view. Smart contracts are not squishy. They execute exactly according to the code, and when there is a problem, as there often is, you can patch it, you can fix it, you can upgrade it, and you can know a priori how the system will actually operate. You can never do that with men, with human regulators. This is a step function improvement, and so far from being a tool of anarchy, cryptocurrency, blockchains, DeFi should be seen as a tool of ultimate order. And that's a very different kind of perspective, I think, that is worth noting.
So before getting to Michael, Rebecca.
Just very briefly, I want to pick up on something that Omid and Kevin both said, but Omid had said trust is the only product of the financial services industry, and I think even with the heavy regulation we have on the financial services industry, both via the SEC and the CFTC and the numerous other regulators that we have in the U.S., which is very different than other systems around the world, I think there is very little trust in the financial services industry, and Bitcoin was born of that lack of trust in many ways. And that, to Eric's point, we need laws because humans do all have subjective judgment. We all are coming from different interactions and different backgrounds. And one of the ways to architect this trustlessness that we find in DeFi, and to pick up on what Jill said, that even in the case of unanticipated events, large volatility, DeFi code or smart contracts will continue to operate as intended as long as it was tested and the like in the right way. And so while I agree that one of the best things we can do, as Kevin said, is to look at all the different risks, I think we have to take a step back and look at the source of risk, because even if a risk is user loss, where it comes from may be very different than in the traditional securities markets, which is errors in human judgment or holding on to data. And I think most regulators around the world have said, this is a complex question. We cannot solve it in the way we're used to. And even some of the French prudential regulators have put together private French-only working groups to try to figure out this DeFi question, and have put out even sandboxes to say, well, we could do cyber assessments and green light certain types of DeFi protocols to give users the information they need to be able to have the trustlessness to engage in DeFi.
So Michael, I'm gonna just frame up what Rebecca was saying for a sec. I think it'd probably be something we come back to, and then Michael, I'll come to you with a question. So I think, Rebecca, to what you were saying, if I got it right, and just to build on, you got, and others are making similar points, right? You got the risk, what is it, what's the nature of it, what have you. But then you have the whole other cascade of questions that then flow from that, if I'm hearing what, again, a number of folks are saying, which is, for example, among other things, you got the risk. What's the nature of it? What's the magnitude of it? How would you regulate it if you wanted to regulate it effectively? At what cost? What are the trade-offs associated with trying to regulate it, whatever it is, in a particular way or another? And then you have another question, which maybe we'll kind of park for now, come back to later if folks want to, which is, even if you find answers and say, you get to the end of that list of questions, there are other questions that you could tease out. You get to who ought to be the one regulating it. Right, so that's yet a whole other question, and that can be a function of regulatory expertise. It can also be a function of just statutory authority, which of course that can change in terms of what legislative action there may be. So the who ought to regulate, I think, is a really just important question, the authority question, the expertise question, that itself can be difficult to answer as if all the other questions were somehow easy. Those are difficult too, but then you have the who ought to regulate it, which has its challenges in terms of just trying to zero in on what the right answer is. But Michael, feel free at this point to comment on anything because we've talked about a lot of stuff, but I was interested in something very specific because you have a lot of experience on the investing side of things. And so when you're investing and working with those who are investing, you need to think about a whole host of things that are going to speak to whether or not this particular opportunity, this particular business, has long-term success that on a risk-adjusted basis is worth allocating capital to as compared to whatever the next best alternative happens to be. And there's a lot that goes into that. Part of that, of course, is just flat out what's the business opportunity. On the upside, part of that is what's the risk environment look like, and then part of that is what's going to be the risk management, the compliance requirements, and then to what extent does that actually hinder the ability to achieve the upside, right? So you kind of figure all that stuff out. Doing that in this particular context, where there's all the questions that the panelists have raised, the comments from the commissioners and Chairman Atkins, how do you factor that in terms of the investing, yes, don't in this particular project, whatever it happens to be? And then relatedly, is there a particular something the SEC could do that would make at least that calculus an easier calculus? Another way to put that is to wring some of the uncertainty out of it, so at least you have a better sense as to what it is that you're investing in, both in terms of the opportunity as well as the associated risks.
A multidimensional question, but I'll start with a talk we gave at our research conference that said that tokens are broken. We think that tokens are broken for investors, for founders, for users of DeFi systems. And the reason they're broken is something that SEC can help us with, which is right now, it is more profitable to listen to user demand. We have a founder of a great protocol here. He is competed by people willing to take shortcuts. And the shortcuts are things that users want him to do because it's cheaper, faster, and simpler. We have created an environment that makes it harder for the teams to do it the right way. And what we need to do is create a golden bridge that everyone crosses, that is where the best capital, the best founders, and the right set of outlines for what you're going to do if you want to access this market live. The way we can do that is reacting to the common pattern we've seen in this industry of we have a new demand for use. Someone wants to do something. Our technology is not quite ready for it. We have to make a compromise. It's too complicated to store your private keys, so you give it to someone else. That someone else doesn't do what they're supposed to do. A lot of leverage builds up and we have a crisis and we have to remedy it. In our view, the right way to do this is to give the good actors like Jill and like Stani the equivalent foot to compete with people who do not follow the same rules. And so the market does not know the difference between a lemon and a peach. And the goal of good regulation should be to help people like us price those and market those correctly.
You have a concrete example or a concrete something that illustrates?
So a concrete thing that happens, Eric talked about this a little bit, crypto systems are perfectly verifiable and auditable. We have no issues with that, and people like me get on stage and broadcast that. The problem is what happens outside the protocol. There are market maker agreements where people will pay for transaction volume that are not legible to the market. The market can't synthesize that information and price that is incentivized activity versus what looks like natural activity. Those off-chain agreements need to be disclosed if someone wants to participate in them in our market.
Does that, one last question, then I'm going to come, Gabe, to you. So just, Michael, one last question on that. You used a word that is coming up a lot in the discussions, which is activity or activity. So from what you just described, would you agree, and I don't want to speak for Rebecca, but in terms of what I believe she was saying by way of the activities-based approach, and tell me if I'm mischaracterizing in any way, that's the right way, setting aside what any particular regulation should or shouldn't be, setting aside what any particular risk warrants additional regulation, setting all those big questions to the side, just as in terms of an overall approach. Would you agree with the perspective that some have expressed, focus on activities as a way to think about it wherever that leads?
It's the only way to do it. The reason is the technologists like myself, former software engineer, will come up with a new way to provide the activity if we regulate the technology. If we regulate the agreement, someone will circumvent it. It's about the activity. What you're seeing in DeFi today, there's a market called Hyperliquid that is dominating market share. They're making changes to their software to make it more performance because users want more performance. We need to make sure users understand what they're using and why, and you cannot do that by any other way than what is the action activities being offered by the platform.
Gabe. So once again, given that we've covered a lot of territory, feel free to respond and react and build on anything that's been said. But one of the things that I thought I'd tee up here is, as I understand it, that you yourself spend a lot of time thinking about innovative legal frameworks that get at all the things that have been a focus of discussion here today. So what are some of those innovative legal frameworks, in some sense, picking up on a lot of the different points that have been made, some of which are about regulatory frameworks, some of which are about risks, some of which are about opportunities, some of which are about technology, some of which are about just kind of a different mindset and construct with which to even engage the discussion, which is not easy when we have a very established frameworks and constructs for how regulatory regimes have been built. So in some sense easier said than done. But as somebody like yourself who thinks squarely about that, how to innovate these sorts of legal and regulatory constructs, I presume it's also the case kind of organizational constructs as well, which you can think of as a form of regulation, even if it's not rules and regulations and statutes and law. Organizational structure has a way of channeling behavior, et cetera, activities, and the like. So what are your thoughts?
Yeah, sure. So, I think we're starting to get into the weeds a little bit. A lot of the conversation's been very high level, but I think, the devil's in the details, and I like the devil. There's a few things I would say. I mean, I absolutely agree with everything everyone has said. Yes, you have to look at, there's the system, and then there's the roles of various people acting on it. But we have just had many years of lawsuits and other things around facts and circumstances-based tests, namely the Howey test. And I think that no one liked that very much. No one wants to analyze in excruciating detail the facts and circumstances of what everyone is doing on every different system in every different way every single time. So we do have to look at all these things. But the end goal of looking at those things should, in my opinion, be to divide things into categories and players into categories and have rules so that people know where they are. And of course, there are always edge cases. Yes, that's why we go to the SEC and we talk to them. We get no action letters, or we have, litigations to figure out the edge cases. But we should be driving toward rules. And I believe, there is a difference, as Michael was saying, between a decentralized autonomous system and a system that just happens to be on a blockchain but isn't actually decentralized and autonomous. And we're going to need in law some recognition of this, where these lines are. They may not be perfect, there may be edge cases, but we're going to need it. Now, I do think that, in terms of why are we doing this? Why does it matter? What is on which side of that line? Well, the reason is that basically, if you do this right, if you have a decentralized autonomous system, it's not that there's no trust in no one and that no people are involved, or it's this beautiful transcendental machine, but rather you don't necessarily have to trust your direct counterparty. And the things that you are trusting in generally are not individual people's discretion or that they're good people or whatever, but it's rather their incentives and their powers, right? And so what regulation should do and what legal constructs should do is help support this wonderful feature. Because if the United States and North Korea can transact on a blockchain, or if two powerful corporate competitors can transact on a blockchain, where typically they would have to use, you would have to put millions and millions of dollars into a bank escrow, and they would worry, what country is the escrow in? Does the president of that country know the president of that bank, or whatever? You don't have to do that anymore. You do it on the blockchain, and you can just trust in a broadly distributed, geographically diverse group of validators, incentives, and their very limited powers, right? So the way that law can support this is a few things. Number one, there are some things that aren't on-chain, as Michael was talking about. There are market maker agreements. There may be agreements between the validators of a protocol and the labs company or foundation of a protocol where they're getting subsidized in certain ways. That is very important information to everyone to know, because that changes their powers and incentives potentially, right? So we need a notice and disclosure regime that captures these potential conflicts of interest or these potential off-chain things. Number two is many, many things are trust minimized by the systems themselves, right? But there are some things that are not trust minimized by it. So Rebecca mentioned the case of a multisig, an emergency multisig that can stop a protocol, and that could be very trust minimized. Like maybe the only thing you can do is you can stop the trading and you can turn it into withdrawal only mode, but there's no way that this multisig can withdraw the money. Well, still, nevertheless, there could be that multisig could just it's only supposed to be for emergencies and hacks, but maybe a government just really doesn't like the protocol and it sends everyone an order to just stop it because it doesn't like it, or because one of its enemies is transacting on it, right? And so there can be, there should be some legal arrangements still that say, okay, you're supposed to be an emergency multisig. Let's define emergency. Let's define what you will disclose your conflicts of interest. Let's define, is there some procedure that perhaps can happen where instead of doing something bad that people have been told to do, they just resign from it and control reverts to the DAO, right? So, I call these things cybernetic organizations, aka Borgs, where basically you have a mix of legal protections and smart contract protections. In that example, the smart contract protection is that there's not very much they can do to the protocol. They can turn off the trading and they can turn it into withdrawal only mode. That would be a smart contract protection. And the legal protection would be the procedure whereby you define what an emergency is, when they're supposed to act, and when they're not supposed to act, right? So I do think that law has an important role here in sort of bringing out the best of this technology's capabilities to allow potential adversaries even to still commercially transact.
So Gabe, I'm going to ask a quick follow-up of you. Then we go to Peter. One, I think Peter has a thought. Number two, I'm going to give Peter the chance to talk about low for a moment. But I would encourage everybody else, since we've now gotten through and there's already been some interaction, if you want to just catch my attention, wave your hand, what have you, I can get the queue going. We'll get through what we can in the next 15 minutes or so before the break, and then we'll pick up on it as well as with the benefit of the audience and their input after the break. So feel free to get my attention if there's anything you want to talk about. Hopefully there is. I'll create the list. But Gabe, real quick, and then Peter, to you. So in terms of what you're saying, kind of the cybernetic construct that you just mentioned, for the SEC, so I'm sitting back putting my former hat on. I'm like, all right, that's really interesting stuff. So now what do I do? Right? So we just got to get to that very bottom line question, particularly when you think about it from the perspective of the SEC's authority. And to the extent, part of the answer is to say, these are really interesting things, but they're really for somebody else, whatever your thoughts are. But I think that would be useful to see how what you said kind of translates for agencies like the SEC or perhaps other financial regulators.
Right. It's the SEC fundamentally has a disclosure mandate. And I think that is a very, very powerful innovation. I realize people in crypto currently think it's very bad, but at its core, and there have been many things. Look, there have been many things that make it perhaps not ideal, because there have been layers and layers of things where it's creeped from a disclosure regime into somewhat of a conduct regulation regime, right? Like if you you force everyone to do environmental disclosures, that can end up being a conduct regulation because they don't like the things they would have to disclose as a result of that, and so they change their conduct. But at its core, and then there's things like Sarbanes-Oxley, which have so many layers of auditing and certifications and controls, these would be completely inapplicable to crypto, right? But if you just go back to the core intuition that investors and other types of operators should have all material information that they would want to have to reasonably make intelligent decisions about things. Not everything in crypto is on chain, right? And so you have to look at where are the potential conflicts of interest, where are the rooms for collusion, where are the ways people could break these systems, and require disclosure around those. That would be enormously useful, and I think that's really all you need. You don't need to regulate conduct that much. And the other thing would be to recognize where the information is already transparent, it's already on chain, then you don't go and require redundant disclosure because everyone can already see that, right? And so it is different, but it's a disclosure mandate, and the SEC would be good at that.
Peter.
The initial thought I had is that, I mean, we're not going to want, say, an emergency on a particular specified escape hatch multi-sig contract to be something that the SEC defines, right? This would be a mess of a rulemaking that I can only imagine the kind of feedback we get from a public comment process. What you want is an emergent order here where people feel comfortable disclosing exactly how they want to set up their system and making very clear to the user how they're going to set up their system such that when they betray those expectations, you can pursue fraud claims against them. Now, an interesting question is, can we just use typical fraud jurisdiction? Do we want to use the SEC's anti-fraud jurisdiction? And are there issues with things that aren't swept into that? Would there still be things left on the table? And so, briefly, I put in my 2 cents. I think when you have a new emergent marketplace with new actors who are doing new and novel things, you actually want more of an organic regulatory model where people can define their own terms and then can be prosecuted for fraud for failure to live up to those terms. You don't want a prescriptive regulatory regime where people are forced to fit into buckets that have been defined ex ante by a regulator, even if that regulator is very smart. They're going to be short-sighted with respect to all the many flowers that will bloom in that world. And so, briefly, to try and bodge this together with what I wanted to say about SEC versus Lowe is you have an example of First Amendment jurisprudence here where, we have to figure out where the line is between conduct that we can require a license for or registration for ex ante versus conduct that you're going to be allowed to do even if it generates risks and we will only police you after the fact. So Lowe is this disgraced investment advisor he loses his right to be an investment advisor, which is a regulated professional conduct category by the SEC. And instead, he decides to start publishing a newsletter for like 25 cents a page. And in the newsletter, you'll find all of Lowe's best stock tips. And it just so happens that Lowe gets money from the people who issue these garbage stocks and then profits off of having them in his newsletter. But the newsletter is just something that anyone can buy. And this case stretched the SEC's jurisdiction right up to the First Amendment in a way that's hopefully fairly obvious, in that the SEC said, no, you're still an investment advisor. We told you can't do that anymore. You're supposed to register, and you're actually banned from doing this because you did it so badly before. Ultimately, when this went all the way up to the Supreme Court, and White said, actually, I'm free to, Lowe said, I'm free to publish my newsletter. It doesn't have personal advice in it to clients. I don't have clients. The Supreme Court ruled in favor of Lowe. Justice White authored the deciding opinion in a concurrence and said, look, I'm not endorsing this conduct. Things that get written can be bad. But in this case, this person is engaged in the publication of speech. And figuring out what the difference is between publishing that newsletter that anyone can buy, it's not taking fees, by the way. Commissioner Peirce rightly mentioned Ether Delta and the Zach Coburn enforcement action, where one of the fact patterns was that he could adjust the fee on the decentralized smart contract or decentralized exchange smart contract. It's not just taking fees, because Lowe published this newsletter for a fee and got lots of money from the shady penny stock people who wanted their stocks in the newsletter. What Justice White said in his concurrence is that there's a difference between that neutral publishing activity and regulatable conduct where one takes the affairs of their customer in hand and exercises judgment on their behalf. And so if you want a good standard for when suddenly you can be subject to some sort of regulation, I think you're right there. If you take the affairs of the customer in hand by designing an emergency escape hatch that you describe clearly, and then you betray those expectations, you're now engaged in something that looks like conduct that can be subject to regulation and not engaged in pure speech. So hopefully I mix those two things together. But
Got it. Eric.
Yeah, I worry that this disclosure thing is a bit of one of those good intentions that paves the way to hell. I don't imagine many of you are happy going to a website and clicking on accept all every single time you visit a new website because of GDPR compliance. Does anyone believe that that has improved the human experience? No. How many of you, when you get a new credit card, read through the 15 pages of sometimes capital letters, sometimes bold, sometimes small print, to make sure that you have read all of the regulated disclosures provided by the credit card company? You don't. These things have a way of snowballing, and a much more reasonable, civil, freedom-oriented way to handle this stuff is through the notion of fraud. Basically, in your example, if a new project is doing some kind of market maker deal, well, if you're going to invest in that project, you should perhaps ask them if they're doing that kind of thing. Ask them. Ask them to affirm something. Ask them to deny something. It can be in a public setting, a public message board or anything like that. They will then have to answer. If they don't answer, maybe that's a red flag and you should stay away from that investment. And if they answer and then they act not in accordance with their own statements, now that is fraud. That seems like a very appropriate way to actually go after bad actors because they're actually committing fraud. There are too many different types of things that might have to be disclosed for this idea that disclosure should be a regulated forcing function. It sounds good, and it's going to lead to the experience of DeFi and crypto getting much worse. And I think now is probably the time to not tread down that road.
Why doesn't requiring Apple to do disclosures make the experience of using an iPhone worse?
Which disclosures are you talking about?
Their 10Ks, their 8Ks, their SEC disclosures that they make. It doesn't affect using an iPhone at all, and it does help the market value Apple stock, get ahead of issues, know that their financials are accurate. I don't quite get it.
I have no problem with Apple deciding to disclose things because huge investors with billions of dollars demand that kind of information.
But they're legally, but it's not really scalable for financial markets, right? Part of the reason why the capital markets, the capital equity markets work beautifully is, every individual investor doesn't go and have to talk to Apple management, right? It's just disclosed. And, it's also not, because they're required to say certain things, as you say, they must actually say something in order for it potentially to be fraudulent. Everyone has the same information. They don't have to go and actually talk to Apple about it, and everyone's in parity. I think there's a certain beauty to that. Now, it can't go too far, obviously, and there are trade-offs, right? But this is part of why markets work and why Apple can trade Apple stock can trade at great scale by many institutions, is because we've solved that social scaling problem through law. Everyone gets the same information.
Standards of disclosure can absolutely be handled by marketplaces. Like if you're an exchange and you want to be reputable and you want to draw volume to yourself, it's in your interest and it's in the interest of your customers for the assets that you list to provide certain information that you think is appropriate. And I think it's not a scary world to imagine that different exchanges might have different listing requirements. That's okay. It's okay if not everyone does the same thing. It's okay if not everyone is forced into the same regime. And that flexibility, that dynamism, is precisely the thing that allows markets to grow and for innovations to happen. There's a lot of, if you go into this disclosure issue, a lot of the reason that crypto tokens are not securities is because to become a security, registered as a security, they would have to abide by these disclosures, many of which don't even apply to them. And
absolutely, you would have to tailor the disclosure regime. I would just leave you with one question, and we should probably
then we're going to move on.
But one quick question just to think about. why were these disclosure rules invented in the first place? Why didn't, in the roaring 20s, when it was a very free market, why didn't all these people get together and just start disclosing these things? Why did we have to pass a law about it?
We can bracket that. Maybe come back after the break if folks think that going down further the disclosure. I mean, to the extent disclosure, it's interesting because disclosure is often seen as a less burdensome regulatory technique than substantively regulating conduct or activities as such. And yet, disclosure can be difficult as well to craft a disclosure-based regime that itself is effective in terms of what's disclosed, how it's disclosed, when it's disclosed, how frequently it's disclosed, and all the rest. So it's notable, just as a general proposition, that while disclosure is sometimes seen as easier than conduct-based or substantive-based or activities-based regulation, it is by no means easy. And part of it is thinking about, from my perspective, part of it is thinking about the ways in which those to whom the information is being disclosed actually engage with the information. Does it actually improve their decision-making, or does it frustrate their decision-making in a way where disclosure may prove to be counterproductive? So it can be a complicated crafting the right disclosure regimes in any particular context can be complicated, setting aside this particular context. So I think there's probably more to come back to on all of that. But let me go to Jill.
Thank you. As both a consumer of products in the DeFi space and the broader blockchain ecosystem, and also a founder behind some of them, I am strongly motivated by both the value and the value proposition of transparency. And for that reason, I think that disclosures, whether they're mandated from an oversight body or a regulatory body, or whether they have just become industry best practice, I think they're enormously helpful. I'm speaking even from my own personal experience as a consumer. As I mentioned earlier, these systems are extraordinarily complicated under the hood. I don't read the 15-page credit card agreement when I sign up for a new card, nor do I audit my own smart contracts as a consumer when I'm using products. But in both cases, I think the transparency and the fact that there are people in each respective industry who are scrutinizing these transparent details is extremely helpful. It's not an enviable position to be in, to either be on the industry side and trying to promote self-regulation, or to be an oversight body to try to walk the line between being overly burdensome and creating a regime and a set of best practices that people abide by that is actually helpful to consumers. I want to touch very briefly on what I think is at stake on that front. If I was to draw a thread through my career, a common theme has been the great assets that the United States has in terms of being able to attract capital, both due to the dynamics around its capital markets and due to the power and the strength of the US dollar as a means of savings and of payments. I live in Silicon Valley, San Francisco. It is the hub of innovation globally. Every social network, every AI application that you use, that you have on your phone, has been invented there. I am one of a handful of crypto founders left there. I want to emphasize that. This was not the case 5 or 6 years ago. It used to be a buzzing hub of crypto activity. It is rare these days to come by someone who is still living not just in Silicon Valley, but in the United States, who is an entrepreneur in this space. And it's due to the regimes that not only the U.S. as a government and as an ecosystem and as a set of institutions has imposed, but it's also due to the challenging aspects that Michael Jordan touched upon earlier as an industry ourselves of the practices that have been created. There's been a chilling effect throughout the industry, especially for those domiciled in the United States, and especially on the best, most scrupulous actors in the industry. People sometimes say to me and they question, oh, you still work in crypto? I thought that it was, just sort of frauds and bad actors left there. And that's because if it feels like it's illegal to work in crypto, if it feels like you're doing something bad, it's going to drive out those most scrupulous actors, either outside of the United States or out of the industry altogether. And that's far too often been the case. And I think that it's critical that we don't create overly burdensome disclosure regimes or other regulatory regimes and further drive out the good, well-intended actors. But I also think it's critical that we have norms around transparency so that those who are trying to create best practices that do protect consumers and retail users and investors can thrive and compete against those who are less scrupulous.
All right, so we're at about time for the break so as not to go over and make sure we have the proper break. So here's the game plan. Somebody from the commission is going to give a couple of instructions in a moment. For the queue, I have Omid and Rebecca. There are probably others, so the others can just come up to me during the break. I'll get the list going. Comments and questions that have come in from the audience, we'll fold those into the discussion, and I guess that's it for now, other than a couple of instructions.
Hello. It's my last chance at the mic during these roundtables, so thank you for indulging me. I want to thank everyone on the panel. I've followed many of your work and thinking for so many years, and I appreciate that those of you who have stayed in the U.S. and continue to build. I value your contributions today. You have really defied my expectations. Innovation always feels quick because most of the time, by the time we're exposed to new technology, it has already achieved commercial success and scaled. We see the fully baked product and quickly lose appreciation for the process. A lot of the points made today about the American spirit have really resonated with me. Even my elementary-age children understand the promise of freedom that America promises. They remind me on an almost daily basis that they can't wait to grow up. Because once they do, they won't have to ask permission to engage with a technology that we greatly limit in our house. That's right. They can't wait to have permissionless access to ice cream. We take for granted all the innovation that makes ice cream readily available for us. Hand churns, large-scale factories, and refrigeration. The rules and regulations around the availability of ice cream took decades to standardize, and as a result, we have a somewhat consistent and delicious ice cream experience. We will now take a short break where we, as adults, can have as many ice creams as we want. I invite you to go to the lobby and enjoy some ice cream. When we return, the panel will turn to answering questions from the audience. There are note cards available outside that you can fill out any questions that you have, or you can submit them, as Tori mentioned, at crypto@sec.gov. Ileana is here, and she can take your cards from you, or I can take them as well, and we'll get them to Troy to ask our panelists. So thank you. Please enjoy your ice cream, and see you back here at 3:30.